Presidente Lattanzi, Presidente emerita Cartabia, Professore Irti, illustri componenti della Corte Costituzionale, del Consiglio Superiore della Magistratura e delle Magistrature Superiori Italiane, illustri componenti dell'Accademia dei Lincei e della Scuola Superiore della Magistratura, signore e signore. Dopo l'istruzione ben chiara del Presidente Mattarella, rimango seduta. È un privilegio rivolgersi a un pubblico così illustre e condividere questa tribuna con i presidenti Sciarra e Lenaerts, che in un passato recente ci hanno ambedue onorati inaugurando il nostro anno giudiziario a Strasburgo. Vorrei ringraziare la Scuola Superiore della Magistratura e l'Accademia dei Lincei per aver organizzato questo importante evento e per avermi invitato a rappresentare la Corte europea dei diritti dell'uomo in questa sede davvero unico. Ho tenuto molti discorsi in molti luoghi, ma mai non lontano di Raffaele e Baldassare Perrucci, il che, devo confessare, intimidisce ed è al contempo stimolante. Vorrei anche ringraziare il mio collega e amico Raffaele Sabato, ponte insostituibile tra la Corte di Strasburgo e la magistratura italiana. E naturalmente non posso non salutare il mio predecessore Guido Raimondi, al quale faccio i miei auguri più affettuosi e quelli di tutta la Corte di Strasburgo. Spero mi perdoniate se ho deciso di usare questa bella lingua che imparai più di 30 anni fa a Fiesole, solo nella mia breve introduzione, ma la vita e l'amore hanno voluto che il mio italiano nel tempo sia spagnolizzato. Let me start with some introductory words about the role played by the rule of law within the case law of the European Court of Human Rights, before exploring how and why the Strasbourg Court has sought in its case law to protect judicial independence and the context in Europe in which it's doing so today. According to Article 3 of the Statute of the Council of Europe, every member state must accept the principles of the rule of law, human rights, and democracy. These three core values are closely interlinked and are the pillars on which the Council of Europe and the European Convention on Human Rights, which applies across a legal space covering 46 states and serves over 700 million inhabitants, are based. The rule of law is considered part of the common heritage of Council of Europe states, together with certain political traditions and ideals, as is clearly set out in the preamble to the Convention. And it is or should be a pillar of any national legal order or international organization, and appears in major international legal and political texts, not least now in Article 2 of the Treaty on the European Union, to which no doubt President Lenaerts will refer. Although intuitively, these statements about the importance of the rule of law are not particularly controversial, it may be more complex to define what the rule of law is, and to make a link between that concept and a particular breach of human rights in an international court of law, such as the court in Strasbourg. In the absence of a clear definition of the rule of law in a binding legal text, the work of the European Commission for Democracy Through Law, mentioned by President Cartabia, has been highly relevant in Europe and beyond. In its rule of law checklist, the Venice Commission summarizes the concept as follows. The notion of the rule of law requires a system of certain and foreseeable law, where everyone has the right to be treated by all decision makers with dignity, equality, and rationality, and in accordance with law, and to have the opportunity to challenge decisions before independent and impartial courts through fair procedures. In Golder against the United Kingdom, handed down by the Strasbourg Court in 1975, the court based itself on the right to a fair trial guaranteed by Article 6, paragraph 1 of the Convention, from which it inferred the inherent right of individual access to court. With reference to the rule of law, which is mentioned in the preamble to the Convention, the court stated, and I quote, It would be a mistake to see in the reference to the rule of law a merely more or less rhetorical reference devoid of relevance for those interpreting the Convention. One reason why the signatory governments decided to take the first steps for the collective enforcement of certain rights stated in the Universal Declaration was their profound belief in the rule of law. We can see from this 1975 judgment that there is a symmetry between the approach of the European Court of Human Rights for decades to the values underpinning the Convention, including the rule of law, and that of the Court of Justice of the European Union in its much more recent case law on conditionality in relation to Article 2 and the values listed therein. Since Golder, the rule of law has become a guiding principle for the Strasbourg Court. It inspires the whole Convention. It's inherent in all the articles of the Convention, or as the Court says, it's defined as one of the fundamental principles of a democratic society. Over the years, the Court has, of course, developed various substantive guarantees which may be inferred from this notion, many of which were mentioned previously by the Italian speakers. An efficient, impartial, and independent judiciary is the cornerstone of any functioning system of democratic checks and balances. Courts are the means, as we've just heard, and as you will hear again this morning, by which powerful interests, which may impinge upon the human rights of individuals, are restrained. It falls to the courts to guarantee that all individuals, irrespective of their backgrounds, their colour, their gender, are treated equally before the law. This all seems entirely simple, and pronounced before institutions of your stature, I'm somewhat embarrassed by the simplicity of my words. Yet, as the previous speakers have said, in Europe and beyond over the last decade, the simplicity and the legal truth of these words endures in certain places no longer. In a system of shared responsibility, such as that established by the Convention, the integrity of the system itself requires the existence of strong and independent national courts, able to adjudicate free from undue interference and exercising meaningful judicial oversight over national authorities. It's important to stress that in the case law of the Strasbourg Court, the authority of the judiciary is a transversal notion, which is approached through the prism of different articles of the Convention, such as Articles 6, 8, 10, and 11. And it's approached through the complaints of a diverse group of applicants before the court, sometimes judges themselves, sometimes the parties to the domestic judicial proceedings, and sometimes other persons or bodies with an interest in those proceedings, whether lawyers or the press, as I'll try to illustrate. The protection of the judiciary in the court's case law is grounded in the fundamental role of the judiciary as an independent branch of state power, which enjoys special status in accordance with the principles of the separation of powers and the rule of law. As we know, the role of the judiciary in contemporary public life has changed over the centuries. Judges are and can no longer be just the mouthpiece of the law as described by Montesquieu. Political issues are increasingly brought before the courts, with judges being called to resolve them with reference to the law and subject to legal complaints. Political issues, sensitive societal issues once left for politics and the legislature. Courts are thus put under the spotlight, and powerful leaders supported by strong majorities may attempt to dismantle restraints on their own power and erode the separation of powers on which the respect for judicial independence also rests. Serious attacks on judicial independence in recent years within EU and Council of Europe states have led to a marked increase in disputes before the Strasbourg Court, which raise questions regarding the independence and impartiality of judges. Sadly, we now have extensive case law relating to the recruitment and appointment of judges, their career and promotion, transfer, suspension, disciplinary proceedings, reduction in salary following conviction for a serious disciplinary offence, and removal from post while formally remaining a judge. As rule of law backsliding has increased across several Council of Europe states, we have, for example, and this is just one state, over 450 cases pending, which raise questions regarding judicial independence in Poland. As this has developed, the court has shifted its focus in the case law on the right of access to court, holding, and I quote, given the prominent place that the judiciary occupies amongst state organs in a democratic society, and the growing importance attached to the separation of powers and to the necessity of safeguarding the independence of the judiciary, the Strasbourg Court must be particularly attentive to the protection of members of the judiciary against measures affecting their status or career that can threaten their judicial independence and autonomy. Bilcin against Turkey, from which this extract is taken, and Article 6 judgments of this nature, point to the fact that the court is no longer assessing judicial independence solely from the perspective of the fair trial rights of the person involved in court proceedings, but also from the perspective of judges as litigants themselves and with an eye to protecting their personal and institutional independence. The European Convention doesn't require a particular system of judicial administration, but it does demand that national courts be in a position to adjudicate fairly and independently of the executive and legislative branches. As such, the court has underlined the importance of the separation of powers and the interpretation of the independence requirement, in particular in cases involving the appointment and dismissal of judges. In order to underline the fact that this issue or these problems don't just affect one or two Council of Europe or European states, I deliberately cite an Icelandic case, Astradsson against Iceland, where the Grand Chamber had to examine the process for the appointment of judges to the newly established Icelandic Court of Appeal. The court explained that the guarantee of judicial independence is closely connected to the requirement that courts must be established by law. This institutional guarantee of independence in Article 6, paragraph 1 seeks to ensure that the judicial organisation in a democratic society doesn't depend on the discretion of the executive, but that it is regulated by law emanating from Parliament. And perhaps in response to President Cartabia, Astradsson is a good example of how a court responds to what can be a systemic problem. According to the three-step test introduced in this Icelandic case, a defect in the appointment procedure of a judge leads to a violation of Article 6 if it is manifestly in breach of domestic law. It affects the ability of the judiciary to perform its duties free of undue interference, and the competent national courts fail to adequately review the alleged irregularity and its consequences. The principles developed in Astradsson have since been picked up by the Court of Justice of the European Union and have been applied by us in Strasbourg in several cases involving other respondent states. But this Grand Chamber judgment reminds us that the establishment of independent and impartial tribunals in accordance with law is something which we must seek to protect in all European states, even in those where democracy and the rule of law don't otherwise appear to be fragile. Thus far, I've looked at the requirement of Article 6, paragraph 1 of the Convention. However, as I indicated from the outset, the Convention arsenal for safeguarding judicial independence is not limited to this article. In Baka against Hungary, the President of the Supreme Court complained under Article 10 on freedom of expression that his mandate had been terminated as a result of his critical views in relation to in his public capacity as President of the Supreme Court and as a member of the National Council of Justice. As judges, and this I must really stress whether in Italy or in any other Council of Europe state, we must readily accept a duty of reserve when it comes to public statements and interviews with the press in relation to societal issues which may fall to us to judge. The Baka case and more recent Polish cases don't call into question this duty of reserve, but they address the delicate position of judges when faced with reforms capable of or designed to sap their judicial independence. On the freedom of expression of judges, the court stated in Baka, and I quote, "Questions concerning the functioning of the justice system fall within the public interest, the debate of which generally enjoys a high degree of protection under Article 10. Even if an issue under debate has political implications, this is not in itself sufficient to prevent a judge from making a statement on that matter." The tenor of the Baka judgment, in which the court found a violation of Article 10, is now, sadly, oft repeated in judgments relating to judges and justice system office holders from Poland, Bulgaria, Romania, and beyond. Judges who've brought complaints to Strasbourg following their dismissal or the imposition of disciplinary sanctions. In a Polish case, Zurich decided last year, a chamber of 7 judges, in which Judge Sabato participated, found a violation of Article 10 as a result of a series of measures applied to the applicant, who had been a spokesperson and judicial member of the National Council of the Judiciary, and who was a fierce critic of the Polish judicial reforms. According to the court, the general right to freedom of expression of judges to address matters concerning the functioning of the justice system may be transformed into a corresponding duty to speak out in defense of the rule of law and judicial independence when those fundamental values are under threat. One detects here the very essence of Ecclesiastes. There's a time to keep silent, and there's a time to speak. These cases also refer to the chilling effect of sanctioning judges for participating in public debate on legislative reforms affecting the judiciary. This chilling effect discourages not only the judges who are directly sanctioned, but also other judges within the relevant system from expressing their views about the functioning of the judiciary or judicial reforms. Once again, under Article 10, we see a shift in the Strasbourg Court's case law, the result of several years of experience dealing with attacks in various forms on judicial independence. Turning to Article 8 of the Convention and the right to privacy, the Court usually adopts what we call a consequence-based approach when assessing whether the threshold of severity is met for Article 8 to be applicable in employment-related disputes, including in recent years those involving judges and prosecutors. In Tuleja against Poland, decided last July and not yet final, the Court had little difficulty concluding that the applicant judge's complaint was admissible under Article 8. Central to this finding was the nature and duration of the various negative effects stemming from the initiation of disciplinary inquiry into the applicant's conduct as a judge, the lifting of his immunity, and his ensuing suspension. With due regard to the central place in EU law of the preliminary reference procedure, the Court in Strasbourg held that an interference in the form of an inquiry into the request by the applicant judge for a preliminary ruling to the Luxembourg Court was contrary to Article 267 of the Treaty on the Functioning of the European Union. But given also the provisions of Polish law, this interference was not in accordance with law within the meaning of Article 8. In addition, the Court found that the decision permitting the applicant to be held criminally liable and suspending him was given by the disciplinary chamber of the Polish Supreme Court, a body which could not be considered a court for the purposes of the Convention, following several rulings of both the Court of Justice and the European Court of Human Rights. Tuleja is not the only example of how Article 8 operates to safeguard the judicial independence of individual judges, but it is a judgment which showcases in extensive and, in my view, very fine detail the manner in which the Court of Justice and the European Court of Human Rights go about their complementary judicial missions in defence of the rule of law, a point to which I'll return a little bit later. Since threats to judicial independence, as President Cartabia emphasised, often stem from systemic or structural difficulties at respondent state level, it's noteworthy that in some recent cases, the Court has found violations of the substantive provisions of Articles 8 and 10 of the Convention, but in conjunction with Article 18. Article 18 is a very peculiar provision in the Convention Rights Catalogue. It provides that Convention rights and freedoms can only be restricted for the purposes explicitly prescribed in the Convention itself. The essential purpose of this article is to prohibit the misuse of power. It is rarely invoked, and until recently, findings of violations remained rare. In cases touching on judicial independence, violations of Article 18 were unheard of. This all changed in 2022 and is undoubtedly a sign of the times. The applicant in Todorova against Bulgaria, the president of the Judges Association, engaged in criticism of the Supreme Judicial Council and the executive. The Court found a violation of Article 10 in this case, but it also found that the predominant purpose of the disciplinary proceedings and sanctions which had been imposed on her had not been to ensure compliance with the time limits for concluding cases, but rather was to penalise and intimidate the applicant on account of her criticism of the Supreme Judicial Council and the Executive. An Article 18 violation, this time in conjunction with Article 8, has also recently been found in a Polish case brought by a regional court judge subject to disciplinary proceedings after he sought to verify whether a first instance judge in Poland, who had been appointed by the President of the Republic upon the recommendation of the recomposed National Council of the Judiciary, complied with the requirement of independence. I should stress that many of the complaints introduced by judges from convention states stem from the consequences of judicial and legislative reforms for individual judges. And the court has stressed that the convention doesn't prevent states from taking legitimate and necessary decisions to reform the judiciary. On each occasion, the court seeks to understand what the complicated background to and context of any impugned judicial reform in the respondent state may be. It is not the court's role in Strasbourg to adjudicate upon the appropriateness of reforms or determine their constitutionality under national law. We generally look to the work of expert monitoring bodies such as the Venice Commission, whose reports seek to explain in relation to a given state why extraordinary measures may be necessary in a given context in order to remedy corruption or counter incompetence among the judiciary. What the Strasbourg Court concentrates on is whether an applicant's rights under the Convention are affected by the manner in which the reform is actually implemented. In my written speech, which I'm sure you'll receive, I give a very good example of this in an Albanian case called Kojaj against Albania. The judge in this case was dismissed as a judge and a lifetime ban was imposed on the judge. This was conducted pursuant to the Vetting Act, which was part of a national reform effort seeking to respond to widespread perception of corruption and a lack of public trust in the national judicial system of Albania. The court found no violation of Article 8 in this particular case, as it considered the Vetting Act and related reforms were found to have responded to the pressing social need of combating alarming levels of corruption, and the applicant's dismissal, again, this is a case-by-case assessment, was deemed to be proportionate. Whichever convention article has been at the heart of the court's assessment, 6, 8, 10, combined with 18 or alone, our case law on judicial independence conveys 4 recurring themes. Firstly, although the Convention doesn't require a uniform model for the organisation of national judicial systems, the Court has specified a number of concrete guarantees to protect judicial independence, which are required under the Convention. The adoption of laws with clearly defined criteria and procedures for the appointment and removal of judges is needed to prevent unfettered discretion and arbitrariness by the executive. In addition, disciplinary measures can only be based on unequivocal legal criteria, must be sufficiently reasoned and applied following a fair and independent procedure. Secondly, in the light of the principles of subsidiarity and shared responsibility, the contracting party's obligation to ensure judicial independence is crucially important for the effective functioning of the Convention system itself. The latter cannot function properly without duly appointed, independent and impartial national judges. And this is a point which you also see clearly reflected in the case law of the Court of Justice. Thirdly, all contracting parties must abide by rule of law standards and respect their obligations under international law, including those voluntarily undertaken when they ratified the Convention. Domestic law, including national constitutional law, cannot be invoked as a justification for failure to respect those obligations. And finally, the Strasbourg Court refers extensively in these cases to the complementary rule of law jurisprudence of the Court of Justice, reflecting the synergy between the 2 European courts in defence of judicial independence and the values which underpin the Convention and EU law. While the Court of Justice, as I'm sure President Lenaerts will explain, proceeds on the basis of a combined reading of Articles 2 and 19 of the Treaty on European Union, supplemented sometimes by a reference to Article 47 of the Charter, the Court of Human Rights has instead recourse to Articles 6, 8, 10 sometimes combined with Article 18, sometimes with references to the preamble and the overarching principle of the rule of law. Before concluding, I think it is useful to stress that from the perspective of the Convention and Strasbourg Court, the importance of the rule of law cannot and should not be reduced to questions relating to the independence of the judiciary. There are other strands to the rule of law under the Convention which may be less familiar to the general public, but which are nevertheless of fundamental importance to the types of societies in which we aspire to live. Secret rendition cases, for example, provide a window into how the Strasbourg Court uses the rule of law more generally as an interpretative tool for the development of substantive guarantees under rights set forth in other articles of the Convention, such as Articles 2, 3, or 5. Let me give you an example. The applicant in a case called El Masri was a German national. He was detained at the North Macedonian border, held incognito for 23 days in a hotel room, interrogated repeatedly, subjected to various forms of torture, forcibly tranquilized, and flown on a CIA aircraft to Kabul, where he was held captive for months. Understandably, the Strasbourg Court, on the basis of the evidence before it, found multiple violations of the provisions of the Convention, and it held as follows. It was wholly unacceptable that in a state subject to the rule of law, a person could be deprived of his or her liberty and in an extraordinary place of detention outside any judicial framework. This is not an isolated case amongst our 75,000 cases pending. Similar stories of abuse can be found in al-Nashiri against Poland, al-Nashiri against Romania, Abu Zabadai against Lithuania, or Nasser and Gali against Italy. I mention these cases because they remind us of the multiple facets of the rule of law and of the importance of a robust judicial system exhibiting high levels of independence and impartiality in order to defend the latter. In other Italian cases on Article 3 of the Convention, such as Cestaro and Blair, which concerned the violence inflicted on G8 demonstrators in police stations in Genova, the difficult but essential role played by national judges shines through. In Blair, for example, the Court of Appeal of Italy didn't mince its words when it stated the following. The applicants were treated like objects or animals. Those arrested in the Diaz-Pertini school had been branded on their faces on their arrival at the police station. The Court of Cassation, relying on multiple witnesses, confirmed the violence which had been perpetrated and held the fundamental principles of a state based on the rule of law had been abandoned in the relevant police station. But for the statute of limitations, these cases would not have come to Strasbourg because the national judges had otherwise done the job which it falls to them primarily to do under the Convention. I cite these cases on purpose so that the public understands that dry notions such as the rule of law and judicial independence have real sense and meaning in the European societies based on common values in which we aspire to live, but which we also aspire to leave as a legacy to our children. In conclusion, let me go back to the future. In 1949, as the post-war framework for the protection of democracy, human rights and the rule of law, from which we now all benefit, was being constructed, Hirsch Lauterpacht, international legal scholar and then judge, wrote as follows. Even in countries in which the rule of law is an integral part of the national heritage, and in which the courts have been the faithful guardians of the rights of the individual, there is room for a procedure which will put the imprimatur of international law upon the principle that the state is not the final arbiter of human rights. Then and now, when defending the rule of law in all its different dimensions, the European Convention and the Strasbourg Court, which is established to interpret and apply it as a matter of last resort, clearly matter, a point beautifully made by President Cartabia. And what we see in Strasbourg is not merely rule of law backsliding, but also democratic degeneration and erosion. As my predecessors made clear in the Golder case, reference to the rule of law is not a matter of mere rhetoric. To function effectively, the convention system relies primarily on you, national judges, whose independence and impartiality the Convention both requires and which it seeks to safeguard. Grazie mille.